Of the observations made by the Justice Mahajan regarding Article 32 of our constitutions are illuminating. This section is in the nature of an iron curtain around the acts of the authority making the order of preventive detention. The Constitution has guaranteed to the detained person the right to be told the grounds of detention. He has been given a right to make a representation by Article 22 sub Article 5, yet Section 14 prohibits the disclosure of the grounds furnished to him or the contents of the representation made by him in a court of law and makes a breach of this injunction punishable with imprisonment. Now it is clear that if an authority passes an order of preventive detention for reasons not connected with any of the 6 subjects mentioned in the 7th schedule, this court can always declare the detention illegal and release the detainee. But it is not possible for this court to function if there is a prohibition against disclosing the grounds which have been served upon him. It is only by an examination of the grounds that it is possible to say whether the grounds fall within the ambit of a legislative power contained in the Constitution or are outside its scope. Again, something may be served on the detainee as being grounds which are not grounds at all. In this contingency, it is the right of the detained person under Article 32 to move this court for enforcing the right under Article 25 to that he be given the legal grounds on which detention order is based. This court would be disabled from exercising its function under Article 32 and adjudicating on the point that the grounds given satisfy the requirements of the subclause if it is not open to it to see the grounds that have been furnished. It is guaranteed right of the person detained to have the very grounds which are the basis of the order of detention. This court would be entitled to examine the matter and to see whether the grounds furnished are the grounds on the basis of which he has been detained or by contain some other vague or irrelevant material. The whole purpose of furnishing a detained person with the grounds is to enable him to make a representation refuting these grounds of providing his innocence. In order that this court may be able to safeguard this fundamental right and to grant him relief, it is absolutely essential that the detainee is not prohibited under penalty of punishment to disclose the grounds to the court, and no injunction by law can be issued to this court disabling it from having a look at the grounds. Section 14 creates a substantive offense if the grounds are disclosed, and it also lays a duty on the court not to permit the disclosure of such grounds. It virtually amounts to a suspension of a guaranteed right provided by the Constitution, inasmuch as it indirectly by a stringent provision makes administration of the law by this court impossible, and at the same time it deprives a detained person from obtaining justice from this court. In my opinion, therefore, this section, when it prohibits the disclosure of the grounds, contravenes or abridges the right given by Part 3 to a citizen and is ultra-vires the powers of the Parliament to the extent. There is provision in the Constitution for empowering courts other than Supreme Court or the High Courts to issue the writs by making a law of Parliament. But no such law has yet been passed, with the result that no courts other than the Supreme Court or High Court have got the power to issue these writs. The incidents of the several kinds of writs which our Supreme Court and High Court are authorized by the Constitution to issue now may now be noted. A writ of habeas corpus in the name of an order calling upon the person who has detained another to produce the letter before the court in order to let the court know on what ground he has been confined and to set him free if there is no legal justification for the imprisonment. The words habeas corpus literally means to have a body. By this writ, therefore, the court secures the body of a person who has been imprisoned to be brought before itself to obtain knowledge of the reason why he has been imprisoned and to set him free if there is no lawful justification for the imprisonment. The writ may be addressed to any person, whatever, an official or a private person who has another person in his custody, and disobedience to the writ is met with punishment for contempt of court. The writ of habeas corpus is thus a very powerful safeguard to the subject against arbitrary acts not only of private individuals but also of the executive. Habeas corpus petition becomes infructuous if the detainee is produced before the magistrate. This is all about today's introduction to the Constitution of India regarding fundamental rights and fundamental duties. Thanks, regards.